Are you Mr. Fisher?
Yes, sir.
You think that's a good shirt to show up in court for?
No, sir.
Okay, why don't you change and call back in?
Right out of the gate, courtroom rule number 1, presentation matters. Whether it's in person or on Zoom, judges expect a baseline level of respect. And yes, your outfit can absolutely influence how seriously you're taken. First impressions, they're not just social, they're legal currency.
All right. Sorry.
I'm gonna put you back in the waiting room and we'll take another matter first.
It doesn't matter. We'll do that. Tell the guys.
What is your name, sir? What's your name, sir? Yeah, what's your name, sir?
Oh, my name is Stephen Kaler.
Okay. Why don't you come on up?
I'm only as an observer.
Oh, okay, okay.
I guess while we're waiting, Judge, we might be able to address a couple of matters before the court that are scheduled for later on. That would include Mr. Kaler's case, scheduled for 11:20.
This is classic courtroom efficiency. When one case stalls, attorneys pivot fast because court time is limited, and every minute counts. Think of it like air traffic control, but for legal disputes. Everything has to keep moving.
Okay, grab those. All right, so the two files with Mr. Nathaniel Kaler. Yes,
Your Honor, I
Mr. Keel?
believe you do have a potential resolution, although Mr. Kaler has...
Here's where things get interesting. Recovery court program. This isn't just legal jargon. It's a specialized track designed to help defendants dealing with substance issues avoid harsher penalties by committing to treatment. Translation: the system offering a second chance, but with strict accountability.
requested at this time that he be allowed to screen for the recovery court program. This was a relatively new request. We just came to a resolution on this not long ago. So we're asking the court to adjourn this matter out for a few weeks so that he can be screened for the recovery court program. He's currently incarcerated. I guess he would remain there until he was screened. So to eliminate the need for him to appear in court today, we would just ask this matter be adjourned out until, I don't know, maybe early August so that he could be screened for that program.
Okay, any objection, Ms. Goodrich?
No objection.
Okay, so we will not need Mr. Kaler brought out. Mr. Kaler's cases, files 216133FH and 6134FH. We're going to continue the docket calls to allow him to apply for the 53rd Circuit Recovery Court program. And we'll continue both of those to August 10th at 10:40 a.m. And we'll have those scheduled in person in the courtroom. Anything further on those files, Mr. Keel?
No, Your Honor.
Okay, Ms. Goodrich?
No, Your Honor.
Okay, so sir, the case will be adjourned to August 10th. Have a good day.
And Your Honor, we also have a matter scheduled for 11:30 for a Nikki Schweizer.
Okay, that's file 21-6129, Mr. Schweizer. I have a note that he's in a residential Veterans Administration Treatment Center in Battle Creek. Is that correct?
That is correct, Judge, and we sent the paperwork in verifying that. He's also had his bond, I believe, amended. So we would ask that the docket call be scheduled to August so that he can complete that residential program.
Any objection, Ms. Goodrich?
No objection.
All right, should we put that out to August 31?
I think the 10th should be fine, Judge. I think we could resolve it then. That looks fine.
Okay. Do you know, is he, let's see. Okay, so he's a Northern Michigan resident. Do you have a preference whether that would be in person for Mr. Schweitzer or Zoom for him?
I guess we would just ask for Zoom at this time. We can always amend that if he's in a position to show up in person, but obviously it would be easier for us.
Any objection, Ms. Goodrich?
No objection.
Okay, we'll continue this docket call then to August 10th at 11:50 a.m., but allow a Zoom appearance. And I think we have Mr. Soulier in the Zoom room from the jail. All right, we're next up. People of the State of Michigan versus Christopher Soulier, file 21-6091FH. We have Mr. Soulier from the Sheboygan County Jail by video. His attorney, Mr. Keogh, is present in the courtroom, or I'm sorry, is present on Zoom video, and the prosecuting attorney, Ms. Goodrich, is present in the courtroom. We're providing public access online. This is the time and date set for a docket call and bond violation hearing. Mr. Keogh, do you know how we're proceeding?
At this time, we don't have a resolution in regards to the docket call. In regards to the bond violation hearing, we would like to proceed with that at this time.
Okay. So we'll have to take some testimony about the missed test. Is that correct?
Yes, Your Honor.
Okay. Well, let's handle Fisher case and the court staff come out for testimony for that.
Thank you, Your Honor.
So sit tight, Mr. Soulier. Let me go off the record for a minute. All right, so we're back on the record. We're calling the case of People versus Alexander Fisher. It's file 18-5567FH. We have Mr. Fisher present by Zoom video with us. Mr. Keogh, for purposes of initial hearing attorney, is present as well. And we have the prosecuting attorney, Ms. Goodrich, present in the courtroom. And we're here today. We are providing public access online as well. We're here today on Agent Fagan's petition to extend the term of probation by an additional year to maintain jurisdiction and supervision due to pending criminal charges in Otsego County. And the new expiration date would be September 18th, 2022, when currently it's set to expire on September 18th, 2021. So, Mr. Fisher, normally in the past, this would have just come to me and I would have signed it.
Pause right here. This is a subtle but important legal shift. The judge mentions criminal justice reforms, meaning decisions that used to be automatic now require hearings. Why? Transparency and fairness. But it also means more time, more scrutiny, and more pressure on defendants.
Under the new criminal justice reforms, probation extensions do, I believe, require a hearing, although the law is not entirely clear on that. So we're affording a hearing on this for you to be heard as to your position on it. So, Mr. Keogh, do you know if Mr. Fisher has any objections to the extension?
I do not, Judge.
Okay, Mr. Fisher, Do you have any objection to continuing your probation for a year? To
Yes,
find out
sir.
what happens in the, what's that?
I said, yes, I do, sir. I've been very good. I've done everything my probation officer has said. I've never missed any time. In fact, I'm early. I'm the first guy at the door. You can ask him in Grayling. And this is just a mistaking of identity. It's cost me $4,000 to prove my innocence. And I'm going to a jury trial. I did not do it. I would not have spent $4,000 to prove my innocence for an $800 fence that I did not take.
What is the offense that's pending in Otsego County?
The fence, they're trying to say that it's larceny over 200, but under 1,000. It was a fence that was taken by somebody, not me.
Okay, well,
and I have
okay.
that I was on a golf course cutting grass at the time.
Okay. Well, Mr. Fisher,
Virus, that's why it's extended due to the virus. Otherwise, it would have been done already.
okay. Well, Mr. Fisher, I
I
will
have
tell
signed
you.
documents from people and everything.
Okay, Mr. Fisher, I will tell you that it has, in fact, been reported to me by the probation officer that you have done well on probation. But we also have a pending
Yes, sir.
criminal case.
I've tried my hardest. I have been taking my medication. I've been working, eating, sleeping. I've stayed out of trouble. And like I said, this is mistaking identity. I didn't do it, Your Honor.
Well, Mr. Fisher, let me put it to you this way. So as far as I know, you're doing fine on probation, but there's an allegation that you have committed a new crime in Otsego County. I understand you got the right to be presumed innocent and you're asserting your innocence and going to a jury trial. So I have two options. I can't exactly discharge somebody on probation successfully if there's pending criminal charges against them. So I have two doors I can go through. One is to violate your probation right now in Sheboygan County because you're alleged to have committed new crimes. And then we go down the violation door. Door number two is to extend your probation to see what happens. And if you are in fact found to be innocent, then we'll just discharge you as successful. If you're found to be guilty, then we'll have to deal with it at that time. So understanding that those are the only two doors I have, to violate you right now or extend it and see what happens. What door do you want me to pick?
I want to go door number two because I know I'm innocent and I'll be let go.
All right. Mr. Keogh, anything further you wish to be heard on it? Okay, you're muted, but I could read your lips to say no, thank you.
No, Your Honor. Thank you.
Okay. Ms. Goodrich, any position from the people?
I have an agreement with the extension.
All right. So, Mr. Fisher, and I want to assure you, we're not doing this because we thought you're doing bad on probation. We're just doing this because we'd rather do this rather than violate you right now. So I am going to grant the probation department's request to extend your probation a year. But I'll indicate, as soon as we know what's going on in Otsego County, if that case is resolved, we'll discharge early. I don't need to keep you on. I just want to keep you on long enough to know what happens in that case. Okay.
Thank you very much, sir.
Okay. You have a good day, sir.
You too, sir.
All right, so we're recalling the case of People of the State of Michigan versus Christopher Soulier. And we're here for a contempt hearing for allegations of bond violation. So Ms. Goodrich, do you wish to call a witness?
I do. I wish to call Melissa Laird, please.
Ms. Laird, could you come up to the witness stand here? Please raise your right hand. You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay.
Will you be seated? Go ahead, Ms. Goodrich.
Can you state your name for the record, please?
Melissa Laird,
And where are you employed?
Sheboygan County.
And what is your position?
I'm the collections and bond compliance clerk.
This is part of your employment duties. Do you monitor the drug bond line?
I do.
And how do you do that?
It's online and I just check it daily. For any missed calls, any missed tests, so I do show problems.
Okay, and in the Christopher Sluyer matter, did you do a motion order to show cause? And was there one dated April 15th, 2021, signed by you on that date?
I believe so.
And what were the missed tests on that one? If you need to refresh your memory.
Well, it's
Your
been a
Honor,
while.
Your Honor, could I ask the
But I
witness to
think so.
speak up? We can't hear her very well.
Okay, that's fine. This is scheduled to be held in person, so if you were in the courtroom, Mr. Keough, you'd probably hear it better.
That's true, Judge.
But I'll ask the witness to speak up. All right.
I believe that's what the dates were.
Okay, so on April 15th, when you filed the motion order to show cause, were there two missed scheduled tests on that date? And was that April 10th and April 14th?
That's possibly so.
Okay, I know that you were not noticed that this was going to be running. Do you have your records in front of
I
you? Okay, would it be easier just to list the dates that?
I guess if that's allowed.
If you can list the dates of missed tests.
Okay.
By Mr. Sluyer.
Okay.
Can we take a break, Your Honor, so she can grab the documentation needed?
Okay, the witness is asking to refresh her recollection by looking at some records that she did not bring with her in the courtroom. Any objection, Mr. Keough?
No, Judge.
Okay, so we'll pass this case momentarily. Please sit tight, Mr. Keough, or Mr. Sluyer. We'll put you back in the waiting room. And Mr. Keough, we also had People v. Beaugrand up at 11:10 a.m. Do you know what's going on with that?
I know that I spoke with him. He was aware of the hearing today. My phone's been ringing off the hook since I've been on with the court. I don't know if that's him calling my office or not, but I tried to leave a message for him, was unable to do so today. I did send him an email.
Okay, so I'll pass on it to the end of your docket, to give him every opportunity to appear then.
Thank you.
All right, we'll recall Sluyer and resume the stand.
Okay. Oh, yes.
So we're recalling the case of People v. Christopher Sluyer. Go ahead with your direct examination.
Thank you. Do you have Mr. Christopher Sluyer's records
I
in
do.
front of you? Okay. And if you could let us know what is showing as a missed scheduled test, what dates?
Yes, April 10th and 14th.
And were there any missed tests?
Looks like there was one, well, I'm sorry, those were two missed tests on that original show.
Okay. And if we could just go over the three show causes now, were there other missed tests since April 10th and April 14th?
This is the additional bond violation. It would be April 23rd, April 26th, and May 15th.
Okay. And then was there a third bond violation filed on June 22nd?
Yes.
And were there missed scheduled tests on that one?
Yes, there was three, May 25th, June 11th, and June 19th.
And between the three bond violations, were there any missed calls?
I believe so, on the original show cause from April 20th. There was two missed calls, April 14th and 18th. And first additional bond violation,
Is that the one dated May 17th?
yes,
Okay. And what were the missed calls on that one?
April 20th, 21st, 30th, and May 7th.
And were there any positive tests among the three violations?
On the April 20th show cause, there was an abnormal test, April 13th.
What about on the May 17th show cause?
Yes, May 5th,
And June 22nd?
June 1st.
And what were they test positive for? Is it the same substance or different?
I believe it was the same substance.
And what would that be?
Can I refresh you?
Yes.
Thanks. April 13th, was buprenorphine. All the same, yes, it was all for buprenorphine.
Okay. And since filing these show causes on April 15th, May 17th, and June 22nd, has Mr. Sawyer provided you any prescriptions or any documentation to show he has prescriptions?
Yes.
And since the date of filing these 3 show causes, has he provided you any proof of taking any tests or calling in to anywhere else?
No.
Thank you. No further questions.
Cross-exam, Mr. Keel?
Ms. Lael, were you made aware that Mr. Sawyer did test on June 11th and provided a receipt from advanced drug testing to the circuit court the last time we were in court?
I do not have those tests.
Has Mr. Sawyer been in touch with you personally in regards to some of the issues that have come to light during the course of his bond?
He has not that I recall.
And how did you receive information about his prescriptions?
I believe it was discussed in court, but I don't remember him calling at all about the prescriptions.
But you indicated that he did have a prescription for the buprenorphine?
We have discussed it in court, but sorry, I can't recall if he does or not. I don't have that in my file, so it doesn't show that he does.
Thank you. I have no other questions.
Any redirect?
No redirect.
Okay, thank you. You can step down. Any further proofs, Ms. Bitter?
No further proofs, thank you.
Mr. Keough, any proofs?
Mr. Sawyer would like to make a statement to the court in regards to his bond violation allegations.
Do you mean he
Yes,
wishes
sir.
to offer any test? Hold up. We're in a hearing, so we're not accustomed to just folks making statements. Does he wish to offer some testimony under oath and be subject to cross-exam?
Sure, that's fine, Judge.
Okay. Mr. Sawyer, would you please raise your right hand as best you can? You solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Okay, you put your hand down. Mr. Keough, go ahead.
Mr. Sawyer, there have been a number of show causes that have been scheduled during the course of your bond conditions for missed scheduled tests and missed phone calls and abnormal tests on June 1st, 2021. Do you dispute that you missed some tests during the course of your bond?
No, I do not.
Okay, and why did you miss the test to your recollection?
I had no money.
Okay, and did you contact the court in any way to let them know that you didn't have enough money to submit to the test?
No, I did not.
Okay, and as far as the missed calls, any explanation for the missed calls?
Just getting them right at the beginning, getting used to the routine. I missed a couple calls, getting in on time. I had a phone issue that I was trying to use a phone app to call, and it took way more time than I expected to get through, and I missed my 10 o'clock time mark.
And in regards to the abnormal test on the 1st of June, do you have any explanation for why that test came back diluted or abnormal?
Probably just because I had to drink water just so I could pee. Diabetic, so like I'm up all night long peeing, and if I don't drink water, I'm not gonna pee in the daytime. So when I have to test, I have to drink water so I can pee. And a lot of times I can barely pee before the test.
Thank you. I have no further questions.
Any cross-exam?
No, Your Honor.
Any further proofs, Mr. Keel?
No, Your Honor.
Closing arguments, Ms. Goodrich?
Your Honor, I believe in defendant's own statements, he admits to missing tests, missing calls, and testing positive or diluting his tests, and just offered an explanation of those things. Thank you.
Thank you. Mr. Keel, closing argument?
Your Honor, I guess it would be our argument that Mr. Sawyer does have a reasonable excuse for not testing based on lack of funds for those missed tests that he spoke of. In regards to the abnormal tests and as far as the missed calls, no argument in regards to that. Thank you.
All right. Well, I am going to find Mr. Sawyer in contempt.
This is the moment every defendant dreads, the fork in the road. Violation now or extension and uncertainty later. It's a strategic decision disguised as a simple choice. And notice how the judge frames it. Clearly, this is about due process, but also risk management.
I think that there is proof beyond a reasonable doubt of that, not only from the testimony of Ms. Leo, but also from the statements of defendant himself. He acknowledges missing some tests, missing some calls. You know, I'm not even considering the positive test because he has the prescription for buprenorphine that his counsel has told us about. I'm accepting that to be true. But Mr. Sawyer, you know, who has quite an extensive criminal record, I was persuaded to reduce his bond earlier in this case and place him out in the community. And given his prior record and the charges in this case, for the safety of the community, we require that he calls in every day and submits to random drug and alcohol tests. And for a big chunk of time, he just wasn't calling at all, wasn't testing at all, missed a bunch of them. I mean, and then he says, well, I don't have any money for the test. He didn't tell the court at the time, didn't tell his lawyer, didn't come up with a solution to the problem. I mean, my goodness, if I said, oh, okay, I think every single defendant who has the drug test would all of a sudden stop testing and say, oh, yeah, I didn't have money. Before we would make a finding on that, I mean, I'm sure that Mr. Sawyer made some purchases over the last, you know, few months. You know, he's just not made any effort to comply. So I do find him in contempt of court. Any comments with regard to sentence, Ms. Goodrich?
Your Honor, I'd ask for the 93 days.
Mr. Keel?
We would ask the court to consider time served in this matter. I would bring to the court's attention that Mr. Sawyer does have a surgery that's scheduled for the 15th at McLaren, Northern Michigan. We have provided information to the prosecutor and to the court in regards to that matter. We believe it's important for him to at least get a furlough to be allowed to have that surgery take place. So any sentence we would ask would include a furlough to allow him to get that surgery. Thank you.
All right, Mr. Sawyer, it's not required that you would make a statement, but is there any statement you want to make to me with regard to what I should do about your contempt?
I'd like to apologize, Your Honor. I was doing the best that I tried, and I never thought of calling the court. I never, you know, I talked to Mr. Keel about it when he messaged me about the things, the violations. I just never thought about calling the court saying I didn't have the money, and I know I mentioned, I heard you say something about a prescription, and I know I did have my pharmacy fax her prescription. I don't know whatever happened to that, but I brought another one in the day of court.
Okay, thank you. Well, I'm going to, on the contempt, sentence Mr. Sullier to 93 days in the Sheboygan County Jail. He gets credit for 14 days previously served because I revoked his bond on June 30th. The bond continues to be revoked. So what will happen is once he serves the contempt sentence, then his bond is still revoked, but at that time, Mr. Sullier can petition for reinstatement of bond and the court would consider it at that time. But he won't be released until he serves the contempt and then we have a motion about reinstatement. And in terms of the surgery, I mean, I was handed today a document for an ambulatory surgery. It doesn't have a whole lot of detail to it. I mean, it's not a whole lot of information to it. I'm not a doctor, but it sure doesn't look like it's, super medically necessary. I'm going to entrust that to the jail. They have nurse and medical services in there. If there's a medically necessary service that Mr. Sullier has, then he's going to receive it. And I'm going to get a request from the jail administrator for a medical furlough. But just because he had something scheduled before his bond got revoked does not make it a medical necessity. So I'm not going to enter any furlough at this time. He'll remain in Sheboygan County Jail. As to the docket call, Mr. Keough.
Your Honor, I guess we have this matter set on a trial path, so we would just ask that we have this matter scheduled.
Okay. Let me add into our jury trial list. In terms of the age of the case, looks like a preliminary examination was held on February 12th of 2021. Mr. Sullier's been in custody since June 30th. How many days do you estimate for trial?
I believe we thought 2 the last time we were in court, and that's
Does that include the jury selection?
probably not, probably 3. If we include the jury selection, that'd be day 1 and then 2 days for the trial.
3 days, including jury selection. Thanks, suffice, Ms. Whittle.
Thanks, more than enough.
Okay, we do have a couple cases that have been pending longer on the jury trial waiting list than Mr. Sullier's. So I've added in to the list. And what I'll do is I'm going to continue the docket call then to August 10th at 10:30 a.m.
Your Honor, I just noticed on my schedule, and I had a few matters that were scheduled on the 10th today. I just realized that I do have a jury trial that's scheduled in another county that day. So I guess I would ask if that could be put at a later date.
Okay. I'll set this for August 31st at 10:30. for a docket call in person. Anything further on this file, counsel?
No, Your Honor, thank you.
Ms. Goodrich?
No, Your Honor, thank you.
All right, Mr. Stulia, we'll see you at the end of August.
All right.
And Mr. Beaugrand, Mr. Keough, you have any word on him?
I do not. At this time, I was going to make another phone call and check my voicemail and see if he's reached me. I do have Mr. Pulowski that is scheduled for a arraignment and a plea. So I don't know if he's currently in the jail. We have submitted the plea paperwork to the court. I can attempt to call Mr. Beaugrand again while Mr. Pulowski is being brought into the court.
Your Honor, if Mr. Keough was in jury trial on August 10th, do we need to reschedule Kaler, Schweizer, and Christopher?
Well, he also had 1, 2, 3 other matters already filed. So I'm not going to go back on the record and tweak all those. We'll have to get a stiff or something.
Okay.
So Mr. Keough, if it looks like your trial on August 10th is going to go, we already had some things already set for you that date, and now others we've added today. So we'll have to get a global stipulation from you or something.
That's fine, Judge. I'll
Work with the assignment clerk to find new dates for those then.
Very good. Thank you.
So we can put Pulowski in the Zoom. So we can go off the record for a moment. Just got to get Mr. Keough here. All right, we're on the record in People of the State of Michigan versus Stephen Pulowski. We have 3 files up, 21-6128FH and 6136FH were scheduled for sentencing. We also have an arraignment on a new charge, 21-6166FH. And Mr. Keough, has Mr. Pulowski been provided with a copy of the felony information?
Yes, Your Honor. We would waive the formal reading of the same and ask the court to enter a plea of not guilty.
And is a forensic center referral requested?
No, Your Honor.
All right, and do I understand that there is a plea to be entered today to the charge with sentence recommendation for Sheboygan County Recovery Court?
That's correct, and restitution of $20.
Okay. Mr. Pulowski, you wish to enter a plea according to the terms of that agreement?
Yes.
Please raise your right hand, sir. Do you solemnly swear that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, put your hand down. Would you state your name for the record?
Stephen James Pulowski Jr.
Mr. Pulowski, this is an important hearing because you're waiving constitutional rights you have, so listen carefully. If you need to speak privately with Mr. Keough at any time, you just say so. Do you understand that?
Okay.
You're offering to plead guilty to a charge of delivery of buprenorphine as a habitual offender, 4th offense. That is a felony crime with the habitual that's punishable by up to life in prison and or a $10,000 fine. And unless you're sentenced to more than a year in prison, the court will impose sanctions on your driver's license. Do you understand the maximum that you could face?
Yes.
Are you on probation or parole anywhere?
No.
Now, this offense is alleged to have occurred back in March of this year. Were you on bond for any other case at that time?
No.
Do you understand if your plea is accepted, you won't have a trial of any kind and you'll be waiving your trial rights?
Yes.
And there it is, the ruling. Contempt of court isn't just a slap on the wrist. It means the court believes orders were knowingly ignored. Even with explanations like lack of money, the key issue is communication. In legal terms, you don't just fail, you fail to inform.
Did you read and understand the rights listed on the advice of rights form?
Yes.
Did you give Mr. Keough permission to sign your name to that form?
Yes, sir.
And do you understand that by pleading guilty, you're giving up the rights listed on that form?
Yes.
Is that what you wish to do today?
Yes, sir.
You understand if your plea is accepted, you're giving up any claim that it was caused by promises or threats that no one tells me about today?
Yes.
You're also giving up any claim that it was not your own free choice to enter the plea?
Yeah.
Do you understand by pleading guilty, you waive the right to appeal, and if you wanted to appeal, you'd have to get permission by filing an application for leave to appeal? Do you understand that?
Yes.
And also, the types of issues you could raise are more limited. A guilty plea waives some issues entirely. Do you understand that?
Yes.
There's a plea agreement in exchange for your plea of guilty to delivery of buprenorphine habitual whore, payment of restitution of $20. The prosecutor will dismiss the drug double, and there's a sentence agreement for Sheboygan County Recovery Court. Do you understand the terms of that plea agreement?
Yes.
Mr. Keough, is that a full, fair, and accurate statement of his terms?
It is.
Ms. Goodrich?
Yes.
Mr. Pulowski, do you understand that that sentence agreement for Recovery Court program is not binding on the court? If at the time of sentencing, I decided it wasn't working very well and didn't want you to be in that program, I wouldn't have to allow you to continue in it. Do you know that?
Yes.
But if that happened, you'd be given the right to withdraw your plea. Do you understand that?
Yes, sir.
There's a very, very important exception to that. I want to make sure you understand. If you engage in misconduct between now and the time of sentencing, say you engage in new criminal conduct, you violate a condition of bond, or you fail to appear for court or abscond, by your misconduct, you'd be forfeiting the right to withdraw your plea, even if I don't follow the sentence agreement. Do you understand that?
Yes.
Other than the terms of the plea agreement, has anybody promised you anything to get you to plead guilty?
No.
Has anybody threatened you?
No.
Is it your own free choice to plead guilty?
Yes.
Knowing all this, how do you wish to plead to the charge of delivery of buprenorphine?
Guilty.
So back on March 12th of 2021, were you in Sheboygan County?
Yes.
Did you deliver buprenorphine to a person that later turned out to be a confidential informant with SANE?
Yes.
And did you know that the substance you were delivering was buprenorphine?
Yes.
Did you have permission to deliver that substance to anybody? You don't have a medical license to prescribe that, do you?
No.
All right, and did that delivery take place in Sheboygan County?
Yes, sir.
Do you have some previous felony convictions? In 2004, were you convicted of larceny in a building in Sheboygan County?
Yes.
In 2014, were you convicted of 2 felonies of delivery of manufacture of less than 50 grams of a controlled substance?
Yes.
So you acknowledge you have at least 3 prior felonies?
Yes.
Mr. Keough, you satisfied with the factual basis?
I am, Your Honor.
Ms. Goodrich?
Yes, Your Honor.
Mr. Keough, are you aware of any other promises, threats, or inducements?
I am not, Your Honor. Thank you.
Ms. Goodrich?
No, Your Honor.
And Mr. Keough, in your judgment, has the court fully complied with the requirements of MCR 6.302?
Yes, it has.
Ms. Goodrich?
Yes, Your Honor.
Mr. Pulowski, we've given you a lot of information. It's possible that may have caused you to change your mind. So I ask you once more, how do you wish to plead to the charge of delivery of buprenorphine as a habitual offender forward?
Guilty.
Well, sir, I find that your plea is knowingly, understandingly, and voluntarily made, and that there's a sufficient basis in fact and law to believe you're guilty of that crime. So I hereby accept your plea. I think what I'd like to do is, you're also up for sentencing on the first two charges that we're going to bring you into recovery court. And then this is a straggler case that Sane had. So I'd propose that we would adjourn the sentencing on the two files and set this for sentencing at the same time. Any objection, Mr. Keough?
No, Your Honor. Thank you.
Ms. Goodrich, any objection to that approach?
No objection.
How about we schedule it for July 27th then, just a couple weeks out? Mr. Fagan, would you be able to get a PSI on the new one?
Sure.
Banged out?
Yeah.
So we'll schedule this for a sentencing on July 27th at 11:40 a.m. in person on all three files, 6128, 6136, and 6166. And Mr. Keough, do you have any requests with regard to bond?
Yes, Your Honor. We would ask the court to consider amending bond in all three cases to a PR to allow Mr. Pulowski to begin this recovery court program. We do think it makes sense, since he will be residing apparently at the tea house, that that bond be amended so that when the tea house bed is available, that the bond would be amended to a PR. I just want to make sure that he's placed in a good position so that he has the best chance of success once he's released from the jail. Thank you.
Ms. Goodrich, any position with regard to bond?
No objection to that. Your Honor.
Okay, Mr. Pulowski, I'm going to amend your bond in all three files to reinstate a personal recognizance bond of $5,000. So that's just a recognizance bond. You don't have to post that. And in all three files, it'll have recovery court conditions. We're going to try to push that paperwork through to get you released this afternoon so that you can meet with the Salvation Army and get situated at the transition house. Okay?
Okay.
Immediately upon your release, you're to contact Ms. Pulowski and get situated with the transition house. If something happens where you can't get there tonight, you're to coordinate with her for where you're to stay tonight. And you know, we did this a while back, and within 24 hours you were back in. So
Yeah.
we don't want to repeat that. All right, Mr. Pulowski?
No, you don't.
Okay, all right. You know, this program would be a good program for you if you're committed to trying to beat back this monster, okay? But we need you to keep it together for longer than 24 hours, okay?
Right.
All right, so we'll do that. We'll adjourn the sentencing and set them all for July 27th, and I'll amend the bond in all three files. We'll get you out and get you working the program and see if we can get off to a better start, okay, Mr. Pulaski?
Okay, thank you, Your Honor.
Okay. We'll adjourn the bond violation hearing as well to that same date and time, Mr. Keough.
Very good. Thank you very much, Judge. I was able to get a hold of Mr. Bogrand. I believe that he may be in the waiting room on Zoom.
Okay, he's not yet there.
I'm just going to mute myself and try to get a hold of him again.
Okay. We'll go off the record momentarily, see if we can get Mr. Bogrand in.
Now, we shift into plea territory, arguably one of the most critical moments in any criminal case. When someone pleads guilty, They're not just admitting guilt, they're waiving fundamental constitutional rights. Trial, confrontation, silence. This is the legal equivalent of hitting no turning back.
Sending messages to Mr. Keogh to please reconnect. Got everyone muted here. Mr. Keogh, can you hear? Your audio is connected, but you're muted. All right, Mr. Keogh, we're going to pass that case to 2 p.m. We're into the lunch hour, and Mr. Beaugrand appears to be a Sheboygan County resident. I'm going to ask him to appear in person with you at 2 p.m. in this courtroom today.
Yes, Your Honor. He is, actually, I'm the arraignment attorney, so I may have some other matters. Could it be later this afternoon so there's no conflicts?
Sure. How about 3 p.m.?
I think that should be okay. We'll make it for 3. We'll do our best.
Okay. All right, thanks. So we'll be in recess then until 1 p.m.
This is the system showing its human side. The judge isn't just sentencing, he's coaching. Recovery court is an opportunity, but also a test. And that line, longer than 24 hours, that's not just advice, that's experience talking. Intro, from wardrobe warnings to life-altering pleas. This courtroom session shows how the justice system balances discipline with second chances. But here's the real question: if you were in that seat, which door would you choose?